Welcome, everyone. My name is Brian Hackett. I'm the Legislative Affairs Manager with the Animal Legal Defense Fund. Welcome to this panel, which will address challenges and opportunities in transitioning away from using animals in research. While there have been a number of strides made over recent decades, and states are passing some laws involving various types of animal testing, such as manufacture and sales of cosmetics tested on animals, there are still tremendous challenges to fully transitioning away from using animals for research. This session will, however, explore the current and future opportunities our movement has to free animals from research, where in instances there are other alternatives or the efficacy of current methods can be reasonably challenged. We have three wonderful presenters today. After the presentations, we'll be taking questions from participants joining us both in person here and online. For those joining us virtually, you could submit questions via the Q&A icon at the bottom of your screen. Now I'd like to introduce our panelists. Their bios and credentials are quite lengthy, so it was quite a challenge to trim it down to a concise intro, but let's have at it. So first, Lenore Montanaro is an experienced attorney and earnest writer with a demonstrated history of working with the nonprofit, state and federal government, and academic sectors. She is licensed to practice law in a number of jurisdictions and teaches animal law at Roger Williams University School of Law in Bristol, Rhode Island. Lenore previously served as an advocacy director for one of the oldest animal welfare nonprofit organizations in the United States. She is also a fellow of the American Bar Foundation, an honor bestowed to only 1% of attorneys in the United States. Finally, she resides in Rhode Island with 2 rescued beagle mixes. Second, Dr. Paul Locke is an environmental health scientist and attorney who holds an MPH from Yale University School of Medicine and a DRPH from the Johns Hopkins University Bloomberg School of Public Health. He is also a graduate of Vanderbilt University School of Law and is licensed to practice the bar before several jurisdictions. Dr. Locke's research and practice target the intersection of environmental health sciences, policy and law in the areas of radiation policy and law, and toxicity testing. His areas of study include alternatives to animals in biomedical testing and toxicity, radon risk science and policy, radiation risk analysis, uranium mining, high-level radioactive waste disposal, and the application of low-dose radiobiology to policy making. Third, Christopher Berry works on a broad range of animal issues, including puppy mills, factory farms, and consumer rights, as a managing attorney at the Animal Legal Defense Fund. He helps formulate creative legal theories to help animals and challenges government agencies that are not following the law. Chris also works hard to fight abuse on factory farms and protect consumers who want to make more humane choices. For example, Chris served as the Cal Cruz on the Cal Cruz hatcheries case, applying the animal cruelty code to a chicken hatchery through the consumer protection law. Chris attended law school at the University of Michigan while maintaining his interest in animal rights with a focus on litigation. So without further ado, you've met our panelists, and I'd like to welcome up Lenore to present first.
Thank you, Brian. I am thrilled to be here. I know we are all thrilled to be here, and we are invigorated by the theme of this year's conference, which is Building a Brighter Future. And in alignment with this theme, please allow this particular presentation and our panel inspire you to continue to be a bright light for the animals as you illuminate the genuine field of animal law, brighten each other, and empower science to do the right thing for animals. According to philosopher Peter Singer, in his book, Ethics into Action, animal protection advocate Henry Spira, who's one of my heroes, famously questioned, what greater motivation can there be than doing whatever one possibly can to reduce pain and suffering? So if you're practicing law and your client directs, or you're not practicing law, but you're directed by another person, entity, by your conscience or otherwise, to problem solve, to find solutions in support of human relevant or animal reduced scientific methods and outcomes or alternatives, then it is critical that you first know the functioning laws and systems that comprise the current body of animal research law. Just as the human body maintains organ systems and cells, so too does the body of animal research law live in a seemingly complex system of agencies, policies, and more. And to make change for animals, we must first know the legal systems and the frameworks. And then we, together, we can imagine and effectuate a vision for change. And as attorneys, advocates, and animal-forward creatives, we can use the law as a tool to empower science to build and create solutions, alternatives, and not allow the law to unnecessarily restrain science by maintaining the current system, which we can argue is not for the best for animals used in research today. So let's talk about these laws and the systems that govern animal research law by beginning with a conversation about two primary federal laws, the Animal Welfare Act and the Health Research Extension Act. The Animal Welfare Act was signed into law in 1966, a little over 56 years ago. And a look at United States history reveals the issue of that animal research law is deeply rooted in the fabric of American society. In fact, advocacy for an animal-reduced science system in the United States, at least, began 100 years prior to the signing of the Animal Welfare Act. And according to Ernest Freeberg, author of the book, A Traitor to His Species, the founder of the ASPCA, his name was Henry Burr, was an abolitionist, unwilling to accept anything but a complete prohibition of animal experimentation. Henry Burr even gave a lecture in New York, which he titled Vivisection Vivisected. He declared that he was going to use the tool of legislative advocacy to put a stop to animal research. But back to the 1950s and 1960s, and the turning point for the advancement of the Animal Welfare Act was due to the plight of a dog named Pepper and related public pressure surrounding her death. Pepper, a Dalmatian, went missing from her family's farm in Pennsylvania. She was taken by a dealer and sold into research where she died. And as a result of this tragedy, Representative Resnick of New York introduced a bill on the House floor, which was the Laboratory Animal Welfare Act of 1966. And with this law, Congress sought to protect owners of dogs and cats from theft of their pets, ensure that animals that were intended for use in research were provided humane care and treatment, and regulate the transportation of some animals. And this 1966 Animal Welfare Act required, among other things, that dealers had to be licensed and had to provide identification for the animals. Covered animals, at least covered under that 1966 law, those covered animals were entitled to humane care, but only prior to the research. Several changes have occurred to the Animal Welfare Act since it was first made law. For example, in 1970, the Animal Welfare Act began to regulate the entire research process, and not just what occurred prior to the animals being in the laboratory. Also, please keep in mind that the Animal Welfare Act, as it is today, is not exclusively about research animals, but of course, for this panel, that's what we're focusing on. Another change for animals used in research a really big change, a great change, occurred in 1985. And this change was an amendment to the Food Security Act of 1985, which was signed by President Reagan in December of that year. And one of the congressional findings, and this was really wonderful, one of the congressional findings for that amendment, the 1985 amendment, was that methods of testing that do not use animals are being and continue to be developed, which are faster, less expensive, and more accurate than traditional animal experiments for some purposes. And further opportunities exist for the development of these methods of testing. And among other things, the 1985 amendment established humane care for animals, including pain and distress. We can look at the regulation to the Animal Welfare Act and see how it defines pain or a painful procedure. That 1985 amendment also established what we understand to be institutional animal care and use committees, otherwise known as IACUCs, and that's the acronym. And in industry, you might hear them referred to as ethics committees. And IACUCs, and there's at least one per research facility, they are self-governing and they really govern the welfare of animals to ensure that an animal's pain and distress is minimized. And that 1985 amendment required that the principal investigator, otherwise known as the PI, that principal investigator who is responsible for the research proposal must consider alternatives to any procedure likely to produce pain or distress to animals. The 1985 amendment established an information service, which is today known as the Animal Welfare Information Center, or AWIC. And that information service, AWIC, exists for people to have information about improved methods of animal experimentation. AWIC was in part created to prevent unintended duplication of animal experimentation and to provide improved methods of animal experimentation, including methods which could reduce or replace animal use. And later in 2002, the Animal Welfare Act was again amended, this time to change the definition of animal to exclude birds bred for research, rats bred for research, and mice bred for research. Now, the Animal Welfare Act is currently enforced by the United States Department of Agriculture through the Animal Plant Health Inspection Service, otherwise shortened as APHIS. And the current Animal Welfare Act does many things, but one way that helps me understand what it does is by categorically putting its functions, its systems in boxes. So what I do is I think of its functions. So the Animal Welfare Act governs licensing and registration, disposing and obtaining animals, record keeping, treatment requirements about those IACUCs like we talked about, requirements about investigations, inspections, and penalties, and so on. Now that we've talked about the Animal Welfare Act, let's talk about the Health Research Extension Act. And the Health Research Extension Act requires the National Institutes of Health to establish guidelines for animal activities that are conducted or supported by the Public Health Service. So what does this mean? Let's discuss this briefly. The Health Research Extension Act, otherwise known as HERA, requires the National Institute of Health Director to establish guidelines. And the NIH director does this through the NIH's Office of Laboratory Animal Welfare, otherwise known as OLAW. So just simply, the NIH director through OLAW establishes guidelines. And these guidelines are known as the Public Health Service Policy. And the guidelines are established for animal activities. So what is an animal activity? Well, unlike the Animal Welfare Act's definition of animal, which excludes certain animals, the Health Research Extension Act defines animal as any live vertebrate animal used or intended for use in research, research training, experimentation, or biological testing, or for related purposes. And this means that some animals might be covered under the Health Research Extension Act, even if they're not necessarily covered under the Animal Welfare Act. Next, when we talk about conducted or supported by the Public Health Service, that really brings in the work that is conducted or supported by other agencies, such as work that is done by the NIH, the CDC, the FDA, and other agencies. So now on the slide, you can see that there's HERA, the Health Research Extension Act. And as we discussed, it requires the creation of guidelines. And these guidelines are the Public Health Service Policy, or the PHS. And the Public Health Service Policy contains standards for animal care and use within it. These standards come from the Animal Welfare Act, a document called the Guide for the Care and Use of Laboratory Animals, another document called the Principles, and that has a longer name, but we'll just refer to them as the Principles, and also the American Veterinary Medical Association Guidelines on Euthanasia. And for example, the Principles, which is something that the Public Health Service Policy pulls from, those principles there are 9 of them. And the third one, for example, states that alternative models such as mathematical models, computer simulation, and in vitro should be considered. But more important for our discussion today is that the Public Health Service Policy adopts and incorporates the Guide for the Care and Use of Laboratory Animals. And this guide endorses the principles and the 3 Rs. What are the 3 Rs? Well, established by Drs. Russell and Birch in their 1959 book, Principles of Humane Experimental Technique, the 3 Rs are long-standing standards that we should all strive toward. They are replacement, reduction, and refinement. And you may also hear them referred to as by other names, such as 3 Rs alternatives. And the word alternative in the research context was coined by D.H. Smythe in his 1978 book, Alternatives to Animal Experiments. Replacement means replacing the animals themselves, and we can have absolute or partial replacement. Absolute means no part of an animal is used in the research process, research experiment, and partial means that cells and tissues might be used in the experiment. And while absolute replacement is a goal, it is an ideal, it might also be possible to make partial replacement an additional goal. And this is really depending on the technology. For example, if we have an organ on a chip that uses an animal cell, imagine if the technology would allow that cell from an animal to be created from a cultivated cell, as opposed to from a live being, a live animal that had to be to be in distress or have minimized distress. Reduction means to reduce the number of animals so that the animal herself might be the control and the variable of the experiment. And refinement really refers to the husbandry or making other changes to minimize pain and distress. So rather than doing an invasive procedure on a mouse, for example, it might be possible to allow that animal to have some less invasive procedure, better enrichment, and better husbandry. So as we conclude, let's talk about a few steps to move forward. There are technologies that exist, and we need to support the further development of technology. And as a result, one major step toward transitioning away from reliance on animals in research is to increase governmental funding in animal model alternatives, especially with something called microphysiological systems, or MPS. And an MPS is a mini device that mimics the function, cellular metabolism, or cell dynamics of organs. And these include things like spheroids, organoids, and organs on chips. But MPS might be a more inclusive term when we're talking about these technologies. Another step forward is to support legislative and regulatory and other lawful initiatives to help animals, including releasing them after they're used in research, supporting licensing and other laws and standards that are in place. We really need to raise the status of the animal being that's used in research. Another step forward is to support better welfare of animals, because if animals are stressed in experiments, the results of the experiments can vary, which can cause more animals to be used. Better welfare means better results, which might mean fewer animals. Another step forward is to create accurate awareness of the issue. Just as that Dalmatian Pepper's story inspired the public to get involved and Congress to act, we need more people. We need you to be knowledgeable and aware of the issues. You can speak to the laws and system-based changes. The animals need you. There are other substantive ideas and steps that we can take to move forward. But for now, finally, another step is we can work together in a collaborative manner to build connections with scientists, researchers, and others to craft creative solutions to help the animals that are used in research today and in the future. We must strive toward the 3 R's because perhaps one day soon we'll be able to add an additional R. Remember when science once relied upon animals in research. Remember their lives. I hope that you remember that you are a bright light for animals, and I hope that you continue to be a bright light for animals. If you have any questions at all, either today or at another time, you can find me on LinkedIn or you can send me an email message. I'd love to support your journey as you continue to help the animals. Thank you.
Well, thank you very much, Brian, for the introduction. Lenore, thank you for that great explanation of a really, really complicated area of law. And thank you for the 4th R. Now we have 4 Rs we can look at. I'm delighted to be here today and excited about advancing the slides. And what I'm gonna talk about is why we need an evolution to spark a revolution, what animal lawyers can do and should do to sunset the use of animals in scientific research, toxicity testing, and drug development. And as you know, because this is the last panel on the last day of the conference, I have about 10 to 15 minutes to do this. So I'm not going to be able to go into the detail I'd like, but I do hope that we'll have follow-up discussions where we can talk about this in more detail. So I'm going to actually cover, this is my overview of my presentation. I'm going to cover these points. I'm going to start with what our ultimate goal is. I'm going to look closely at a definition of research. I'm going to talk about the 4 legal fields that demand scientific data, what the shortcomings are of our current federal and state laws that require us to use non-animal alternatives. And then I want to talk about the path forward for the legal community. So what's our ultimate goal here? Well, our ultimate goal here is absolute replacement. One of the R's that Lenore presented. And I would describe that as replacing science that uses non-animal models with non-human animal models with non-living systems that more accurately recapitulate or recreate human responses to improve data and decision-making. So we're going to talk mostly about how we get there, but I want to stop here for a minute and just break this down a little bit. So that's kind of a mouthful. And, you know, we live in a Twitter world. So I tried to think to myself, well, how could I explain this in 50 characters or less? So here's what my conception is. I'm going to put this on a t-shirt. And what's the t-shirt going to say? It's going to say, better science, fewer animals. And because I'm trained in law, I'm going to have a footnote, right? Because you always have a footnote. And my footnote is going to be asterisk, maybe even no animals. So that's the ultimate goal. Now, I want to talk a little bit about what is research. That's a very complicated question, but it's a very important one to try to at least address. So there are basically 3 things you do in research. The first thing you do is you develop a hypothesis based on how you think some biological system works. In my world, I work mostly with epidemiologic data, which is data collected from humans about humans, or toxicologic data, which is data collected from animals or from microphysiological systems or organoids to study how chemicals and other physical things go through the human body and what they do to the human body and the human organs. So the first thing you do is you have a theory about what's happening. Then you collect data and use that data to test your hypothesis or theory. That's the scientific method, and that's what basically research is. Now, the important thing to remember is that all researchers are doing science, but not all scientists do research. And that's not to slam scientists that don't do research. We need those scientists because they're the practitioners, they're out there applying the science, but they're often not in the labs, they're not studying populations. All right, so that's a quick definition of research. Just keep that in mind as I move into the 4 fields of law that require scientific data. Now, when I think about this, I like to divide it into different baskets of the law. So the first basket I look at is the cosmetics basket. And mostly from a scientific standpoint, you're looking at skin and eye irritation or skin and eye sensitization. You're looking at how something penetrates the skin. And the major law that covers this on the federal level, and these are mostly federal laws, is the FFDCA, the Federal Food, Drug, and Cosmetics Act, although there's no pre-market approval required for cosmetics at the FDA. The second kind of basket are chemicals and commerce and pesticides. And we study numerous endpoints there. The most important one is usually human carcinogenicity. But there are a lot of laws that cover this. The major ones are TSCA, FIFRA, and there's some state laws like California Proposition 65. Third basket is laws that cover drugs and devices. And the basic mantra for these laws is we want to put things in the market that are safe and effective. Again, numerous endpoints, including carcinogenicity, but also things like liver damage and heart damage, which is also known as cardiotoxicity. And if I have time, I'll mention that a little later on. Mostly they're covered under the FFDCA and those types of laws. And there is pre-market approval required for anything that goes on the market that are drugs and devices. The final basket or area is really discovery research, and that is developing new knowledge. That's largely NIH funded. And for those of you that don't know about NIH's budget, it's about 42 billion, that's with a B, dollars per year, of which about 25 billion with a B goes out in what they call extramural grants to universities, like my university, Johns Hopkins, which I'm required by law to mention 3 times during my presentation. And this is not data that's produced for any statutory decision-making. It's data produced to try to understand how biological systems work. So that's the universe of the laws that create the demand for really this, what we use now is mostly non-human animal science. All right, so let me quickly just explain why that matters. Well, there are at least 3 reasons. The first reason is that the science needed under each of those baskets is slightly different. And not many people focus on that, but that is true. The second is that each area, as you can see, is governed by a different set of laws or policies. Although there's overlap, but there's a distinction there. The third reason is that there are different, again, but overlapping scientific communities that operate under each of these baskets. The fourth thing I just want to say is that you should not be intimidated at all by the science or the scientific language. Lawyers are smart people, and you can figure this stuff out. As much as I would like to recruit you to get a doctoral degree, again, guess where? At Johns Hopkins. You don't need a doctoral degree to understand this. Okay, so let me now move to current federal and state alternatives laws. There are laws on the books that address alternatives. And it's useful, since we're looking at law and we're lawyers, to really delve into the language a little bit. So I've just picked 2 examples because that's all we have time for, but they pretty much have the same language, same style as other laws that we might see if we had more time. So the first one is a law called TSCA, the Toxic Substances Control Act. You may remember that's under kind of basket 2, chemicals and commerce basket. And what this says is that EPA shall reduce and replace, to the extent practicable, scientifically justified and consistent with the policies of this subchapter, the use of vertebrate animals. All right. So EPA shall reduce and replace the use of vertebrate animals if all these other things happen. All right. There are some state laws on the books that require the use of scientifically validated alternatives. Here's one from Virginia. I happen to live in Virginia, although Johns Hopkins is in Maryland. Okay, I got my 3 times out. We're done with that. And here, while the language is more complicated, the message is the same. An alternative is something that provides information that's equivalent or of better scientific quality and relevance than animal test methods. And it's been identified and validated and adopted by a federal agency. So again, there are steps that have to happen in between. So the key word on this PowerPoint is conditional. The mandates are conditional. All these other things have to happen before we get to use the replacements. So you're going to now wonder, well, why should I care as a lawyer? That sounds like science to me. And to some extent it is, but really the lawyers are the ones who are going to build the road that the scientists walk on. And that's what I want to talk about now. So what should lawyers do? Again, let me stress, the first thing you should do as a lawyer is not be afraid of the science here, because you have a real role as an animal advocate and a lawyer to delve into this, and it is comprehensible, and this is a societal issue. We all have a stake in this. So I would say that there are 3 key actions that we could focus on. There are more, but these are the 3 that pop out at me right now we can start with. The first thing we need to do is we need to advocate to enact laws that actually incentivize the development, use, validation, and regulatory acceptance of absolute replacements. You remember all that conditional language we had before? We got to push past that. We're going to be in a strong position if we can argue, don't use this animal test because this non-animal test exists. That's where we want to go with this. Remember, we want better science, fewer animals. And don't forget the asterisk, maybe even eliminate animals altogether. The second thing we want to do, oh, and I should say there have been some bills that have been introduced in Congress before this. One of them is the Humane Research and Testing Act. The other are their appropriations language that is always talking about funding specific non-animal alternatives. I think we need more of that. Second point we have to focus on is eliminating barriers in current laws that require animal use. So one example of this is the FDA Modernization Act. The animal advocacy community has been great pushing this law and really working hard on it. It is now before Congress. I don't know its current status, but it's probably about this close being passed. And I think we're all hopeful that that goes through. The last thing we have to think about is we need to address issues that are associated with the potential liability due to using data from non-animal methods in decision-making. So how does this go? Let me give you a hypothetical that is certainly on the minds of people in the pharma companies as they develop new drugs, devices, and other things. A drug or device is developed without the use of animals. It comes to market, and when it goes to market, it turns out that it has a deleterious effect on a subpopulation. That someone in that subpopulation then brings a lawsuit against the pharmaceutical company, alleging that if they had done what? Animal testing, this wouldn't have happened. We have to figure out how to eliminate that because that's a business barrier. We need to get rid of that business barrier. All right, so now it's Science Sunday for a minute. I want to just talk a little bit about the state of alternatives. Now, I know all of you probably subscribe to Toxicological Sciences and you've read this article, but the reason I pull this up here is because it does have 3 case studies of using what are known as iPSC CMS, which I'm sure you're all aware are human-induced pluripotent stem cell-derived cardiomyocytes. 6 words you never thought you'd hear at a legal conference. So what's the big deal here? The big deal here is that a couple of things. Cardiotoxicity is really an important endpoint, especially in people who are being treated for cancer, because many chemotherapy drugs can induce cardiotoxicity. We need a way of assessing cardiotoxicity of drugs. These systems, these cells, actually mimic the heartbeat of humans. They're human-based cells. So we have a system here where we can actually use human cells to try to guess what the cardiotoxicity is and get around animals. What these 3 case studies show, though, and I have this outlined in yellow and it's not very visible and I apologize, is that basically right now, these systems provide what the article calls supportive evidence. The bottom line message for us as advocates the bottom line message as an attorney is that we're not quite there yet. These are in development, but we need, again, to do more. I think as Lenore pointed out very well, one of the things we need is more funding for these sorts of things. So let me just go again. Did I? Yeah. Is there a slide missing? Yes, there is a slide missing. Okay. Let me go again then to the ultimate goal. Remember the ultimate goal? Everybody gets a t-shirt when they leave here. We're going to replace science that uses non-human animals with non-living systems that more accurately recapitulate human responses, because we want to improve data and we want to improve decision-making. We have a dual goal here. We're trying to eliminate animals in the process, but we're also trying to improve human lives. And we can do both. Lawyers have a critical role to play in this, because again, lawyers are going to build a road that the scientists can walk on. And that road that we're going to build is one where we have more funding, more acceptance, and more use of these alternatives. And that really is going to make a better world for all living creatures. So with that, I will say thank you. And I really appreciate the conference organizers, the Animal Legal Defense Fund, and Lewis and Clark for inviting me here today. And also appreciate all of you staying. By now, Chris is going to come up here. You should be on Voodoo Donut Sugar High based on my toxicological analysis, and he is ready for you. Thank you.
All right, great. I opted not to do a PowerPoint because I usually have pictures with my stories in the cases, and I didn't really want to subject everyone to that. But also, yeah, thanks for all the great information, and thanks for being here and attending the panel. So what I'm going to talk about, I think, is actually going to be a really good complement to what Paul was just speaking of, kind of the other side of the coin. So the one side is the promoting alternatives to animal research and breaking down the barriers that those alternatives need to thrive. And what I'm going to talk about today is accountability, holding research facilities and government institutions that regulate those facilities accountable. Because I'd like to pose a question, which is how do you transition away from using animals in research when the government isn't enforcing the laws that are on the books, and when people don't even know what's going on inside the research institutions, and that's a real problem. So in talking about accountability, take notes, because what I'll be talking about is something that anybody potentially could launch an entire advocacy campaign from their own laptop in their own personal time and their personal capacity, by identifying a research facility, maybe where you're going to school if you're a student, or one in your community or your state, and using some of these techniques. So there's going to be two components that I want to talk about. One of them is transparency, and the other is legal accountability. And with regards to transparency, this is the ability to understand what's going on inside research institutions, and also sometimes the ability to even talk about what's going on. And this is really important, not only because it's a way to hold the facilities accountable, to hold researchers accountable for what they're doing, sort of just in the court of public opinion, but also because it's also a means to an end. Sometimes you need to know what's going on in order to even know if a law is being violated, if there's a problem with, for example, USDA regulations under the Animal Welfare Act. So transparency is critically important. And one component of that are public records laws. And public records laws give us a glimpse into research facilities, at least a lot of them, not necessarily all of them, but it'll provide a glimpse into research facilities, because there are many ways in which a facility may be regulated. So probably the most Important and significant way is research facilities that do research on mammals other than rats and mice. So, we're talking about guinea pigs, non-human primates, rabbits, cats and dogs, et cetera. Those research facilities are covered by the Animal Welfare Act. And the U.S. Department of Agriculture will inspect those facilities. They're supposed to do it on a yearly basis and generate inspection reports. And sometimes they'll generate more than inspection reports, assess fines. There may be email correspondence, there are photographs related to the inspections that they're doing. So there is a wealth of public records for any facility that is doing research on mammals other than rats and mice. Additionally, the USDA actually publishes these records online. It's the USDA's ACIS database. It's like a public search tool. So you could Google that and find it on the USDA website and actually search by all research facilities by state or city, or if there's a particular institution, you can search for the names of that and get the last several years of inspections. Another glimpse that we can have into the research on animals world is through the National Institutes of Health, which we also talked about earlier in this presentation. And the NIH spends a lot of money on research, including animal research, and their records that the NIH has about facilities that are receiving federal funding are potentially able to be found through Public Records Acts as well. In fact, the NIH actually has a tool. It's called Reporter. So the NIH Reporter tool, where you can search for every single project that the NIH is providing funding for, including by keywords. So you could look for primates, you could look by the type of facility, and there's a lot of search parameters there, and see what the NIH is actually funding. And of course, those facilities are going to be regulated by the NIH policy, which includes rats and mice, as well as all other vertebrate animals currently. So fish, amphibians, and reptiles and birds. There's those are two really important ways of doing research. Additionally, even at the state level, a lot of research is conducted at universities, and state universities are usually subject to state public records requests as well. So that won't just be the government generated kind of inspection reports, but also, I mean, potentially almost everything related to that research, including videos that the principal investigators take of the animal research, or if they have cameras running in the facilities where the animals are sort of being held most of the time, meeting minutes, agendas, the IACUC committees, all that sort of stuff. Potentially, you could find through public records requests. And additionally, sometimes there'll be state or local laws that might play a role too, depending on the jurisdiction, but that's usually not as much. So that sounds great in theory, but in practice, research facilities, they really don't like people being able to sort of easily find what's going on. They don't like to give those graphic photos and videos up. And so what we see a lot of the time is that they will, if there's something that seems sensitive, that they'll pretextually, in my view, assert one of many various exemptions to Freedom of Information Act requests, like trade secrets, or maybe something related to privacy, or like a general public interest catch-all. So they'll potentially use this and try to hide the records. So it's really important that if a specific request is made, and the information that you actually want probably won't be provided to you, to fight that, to do the administrative appeal, and potentially to even sue over it. And what a pattern that I've seen that's really interesting actually is that engaging in a public records fight can actually be a springboard to this kind of accountability, to the sort of social and cultural accountability. Issuing a press release, tipping off reporters who might be covering that sort of state or city, the jurisdiction, tipping off reporters, doing social media campaigns, and so forth, and generating a lot of public interest and a public knowledge about what's going on at that facility in connection with the fight. And people, whatever their view on animal research is, most people are like, well, they want the transparency. They want to know how their taxpayer dollars are being spent. They want to know what's going on. And so it's a really easy way to frame a fight and to get that information out. There was one case that I was involved in. This is Citizens for Alternatives to Animal Research and Experimentation a few years ago in New York versus the State University of New York. And they were doing research, amblyopia, that's like when one eye doesn't move as much as the other one. They were doing experiments on that on kittens, and for decades it hadn't generated any useful results, and there are actually effective treatments to that condition already. So the question was like, why are you cutting open kittens' brains when it seems like you don't have to? They refused to almost give us any information at all. The client in that case, CARE, and so there was a public records lawsuit that we were involved with, my organization, the Animal Legal Defense Fund. Generated a New York Post front page story, and eventually the university pared back and stopped doing that experiment on cats as a result of some of the controversy and I think alum and donor feedback for the university. There was another example too against the University of Wisconsin-Madison. They were doing maternal deprivation studies in the 2010s. And refused to provide meeting minute notes to the Animal Legal Defense Fund about approving that research, why they were taking baby monkeys away from their moms and torturing them. They didn't want to provide the meeting minute notes. And so we took that to the Court of Appeal and won, and generated a lot of public commentary and news coverage in the process, which also led them to pare back that research as well. So that's a form of social accountability. I also want to talk about another form of transparency that's really important, which is the First Amendment. And we could talk for hours about the First Amendment, really even just in the animals and research context, the law of it and all the various kinds of cases. So without getting too much into the weeds, essentially, the First Amendment requires that if the government is going to regulate or restrict speech in any way, that it has to have a good reason for doing so, and it certainly can't do so to discriminate against certain political views or other, illegitimate reasons. So, because a lot of research institutions are government agencies, like state universities, for example, when they also don't like being criticized about animal research as much as they don't like to give information about it up, and so they'll oftentimes engage in efforts to suppress people's communicating about it. And one case in particular really highlights this. So we have a client, her name's Madeline Krasno. She's an alum at the University of Wisconsin-Madison, and she used to actually work as a technician in the primate research laboratory. So she's now an animal advocate, and she'll comment on the university's social media posts criticizing them for their cruel treatment of animals. And their response to that was, well, they blocked her for a while, and then probably thought better of it for legal reasons. But they then also implemented and still have in place a keyword filter. So anyone who posts on their Instagram or Facebook account words such as cruelty, animal torture, kill animals, testing on animals, testing on cats, tests on cats, vivisection, all those, any comment that mentions those words will be automatically hidden on their social media page. So we sued under the First Amendment, and what I think is a very compelling case of viewpoint discrimination, but actually just a couple of days ago got a very unsettling decision from the district court judge in that, saying that she didn't have standing, and that he wasn't going to stop it. So he dismissed that case, but we do have options such as appeal. So keep your eye on that. Okay, so that's transparency. I still have a few minutes left, and there's another side of this that I want to talk about too, which is legal accountability. So not just exposing what's going on at research facilities and talking about it, but also making sure that there's some kind of accountability. And that can take two forms: accountability for for government agencies that are regulating research facilities like the USDA or the NIH, and also accountability for the research facilities themselves when they're violating the law. And so most of the litigation in this realm in advocacy really is focused on the government agencies and their administration of like the Animal Welfare Act in particular. Unfortunately, the USDA, which administers the Animal Welfare Act, is often unreasonably deferential to the industry that it's regulating, to the point where its own Office of Inspector General, I'll just read a couple quotes here, in 2014 found that USDA's Animal Care Unit did not follow its own criteria in closing at least 59 cases that involved grave, such as animal deaths or repeat welfare violations. And previously, in a previous report, the same office had found that the USDA, by reducing Animal Welfare Act penalties so much and making other concessions to facilities, made penalties under the Animal Welfare Act basically meaningless. And quote, violators continue to consider the monetary stipulation as a normal cost of business rather than a deterrent for violating the law. So that the enforcement of the Animal Welfare Act is so weak that it's, and in fact, I've done the math on this. Sometimes it's much cheaper actually just to pay the fine to the USDA after several years of repeat violations than it would be to hire like an additional veterinarian to actually take proper care of the animals. And so when we're talking about alternatives to animals in research, if essentially they're being subsidized by the USDA's own lack of action and their own refusal to enforce the law. And there's a playbook. There are ways to hold agencies accountable like the USDA. So for example, under the Administrative Procedure Act, 5 USC 553, you can ask an agency like the USDA or the NIH to engage in rulemaking. So this is called a rulemaking petition. You can ask it to change its policies or regulations, and they're under an obligation to respond to you and to provide a reasonable, they're not obligated to grant your petition, but they have to provide a reasonable explanation for denying it or for doing whatever they do with it. And if they don't respond in a reasonable time, which is usually about 4 years, or if they don't provide a reasonable explanation, you can sue them under the Administrative Procedure Acts. And that you might modify their behavior that way. But again, that can also be a springboard for drawing attention to an important issue. And there are examples of lawsuits like that, such as some ongoing lawsuits that I'm involved in, attempting to have the USDA have more specific regulations for primate enrichment, which is a statutory duty. However, they defer to research facilities to come up with their own enrichment plan. And as long as they have a plan, then they've satisfied that requirement. But we think there should be actual specific requirements there. So that's just one example of that. With regards to government agencies, you can also, if you don't like what they're doing, if they're refusing to take action when you ask them to, you could just fire off a letter to their Office of Inspector General, and the Office of Inspector General might do something about it, or might act on that complaint, or they might save it and put it somewhere and refer to it when they do their next audit of the USDA's animal regulations. And all of this sort of playbook of rulemaking petitions in the Office of Inspector General would apply also to the NIH with regards to its funding decisions. PETA actually has an interesting lawsuit against them for continuing to fund septic studies on mice, despite the fact that the director had actually admitted that the drugs designed for the mice failed in humans because they were in fact treating different conditions. So that's an actual quote from the director about that. And then lastly, I see I'm out of time here. A last way of holding people accountable is to actually go to the facilities themselves and to try to hold them accountable. You can do that through through these Public Records Act requests, as we talked about previously. You can send letters to law enforcement agencies asking them to take action where there appears to be illegal conduct. So if you look at inspection reports or find something that looks like an Animal Welfare Act violation, send a letter to the USDA and ask the USDA to look into it. And if the USDA doesn't do anything, then send a letter to the Office of Inspector General. And you could do press releases for this all along the way as well, or blog posts or social media posts about it. And additionally, potentially, I think there's some avenues for state law litigation as well. So animal cruelty laws would generally apply to research facilities. There are exemptions, like for example, for properly conducted research, but those exemptions might not apply to, holding the animals in a cage and forgetting to give them water, in a way that's maybe adjacent to, but not actually a part of the animal research. Or you might say that they're failing to follow their protocol or negligently designing a protocol for the research that might not be properly conducted. So I think there are potentially some ways you can argue that animal cruelty there and try to bring that to bear against the facility as well. So with that, I will stop talking, and I think we'll be maybe open for questions soon. So thanks, everybody.
Thank you all for those fantastic presentations. We'll now turn to questions from the audience. So if you have a question, please line up at one of the two microphones in the center aisle. If you are attending virtually, you could submit a Q&A question at the bottom of your screen. Yes.
Hi all, thank you so much. It was super interesting. I have a bachelor's degree in chemistry and biology, and I'm now a first-year law student at GW. And I also have an interest in First Amendment law. So this panel was like exactly what I'm interested in. Thank you. Particularly to Dr. Locke, but if the other panelists have thoughts as well, I'd love to hear. I have two ideas on minimizing the impacts on research on animals. One is transitioning towards focusing on research more on animals that have no or little sentience, like C. elegans. And then the other one, which is a controversial idea, but what about consensual, when humans consent to experimenting on themselves, as opposed to animals who cannot consent to that? I realize that's a controversial idea, and I'm not necessarily endorsing it, but I'd love to hear your thoughts on it.
That's a really hard question. So in terms of the first suggestion you have about using animals, creatures like C. elegans, that research is being done. And the general theory is that there are a lot of biological systems that are what are known as highly conserved across species. So you can look at certain things in a worm, and that does have biological applicability to humans. Unfortunately, there are limitations to that. So I think really where the science is going is to construct these microphysiological systems or to develop like organoids. And organoids are just, you take a group of cells. So for example, if you think about the human brain has several different types of cells. You put those cells together and sometimes they'll self-organize into kind of like they're often called mini brains, but that's exaggeration. They're just a group of cells that mimic brain function. I think that has more applicability because you don't have to guess as much or extrapolate as much. Regarding the human experimentation, I'm really uncomfortable with that. We actually got into the business of using animals because of massive abuses in human populations. So we have a very, very rigorous system in the United States and other places too as well, but I happen to know the US one better, about making sure that before we experiment on humans, we really have a good idea of the right dosage to use, the right organs that are going to be targeted. So I would have trouble with that, but we could talk more about it. I haven't thought it all the way through, to be honest with you. And it sounds like you have done that. So you probably have some good ideas about ways that might be useful.
Yeah, actually, if I could add to that, I guess this is just playing devil's advocate, because in some ways I feel like some of these questions are just, or some of the answers are more like, what's the least bad option? But one thing I would point out too, to keep in mind is that if there is more movement towards maybe like the less cognitively advanced animals, so to speak, those also tend to be the ones that are the least regulated. So that research will then, and the welfare of those entities will then be kind of go further into a black hole. So that's kind of an interesting dynamic and query. You think the law should be, to the extent that's a trend, the law should sort of respond to that trend by increasing the amount of transparency into that kind of research. And then just sort of, this is more of just an interesting point with regards to the human research, that sometimes it's not clear that the line can be blurred, particularly with regards to humanized animal chimeras or animals that have humanized genomes through like CRISPR, which is really interesting, and that is like almost totally unregulated. So that it just raises a question of what is a human research subject?
Thank you for mentioning CRISPR. Yes.
I believe we have an online. Okay, well, we'll go to at the mic first.
Hi, we have these 3 Rs, and I think that they're like such laudable goals. And then we also have IACUCs that supposedly have these all in mind when deciding whether or not to approve a research project. And so I guess I have a couple questions, like what are the makeups, or what's the makeup of these committees, and kind of why do they continue to approve this research? Is there a way to hold them legally accountable, or like otherwise incentivize them to scrutinize research protocol more closely?
Excellent question. Excellent question. So the IACUCs, and it's in the Animal Welfare Act with respect to who should be on an IACUC, who's permitted. And I can share the statutes and the regulations with you after the conference, but essentially the CEO of the research facility will appoint people. But what I think is critical for us to realize is that an IACUC should also, the Animal Welfare Act does require that there should be someone on an IACUC who represents society's general interests with respect to the welfare of animals. And so as advocates, as long as we're following all appropriate laws with respect to confidentiality and maintaining trade secrets, it's one potential pathway forward to include animal advocates on an IACUC, because they are self-governing bodies. And I don't know if there's anything else you'd like to add.
Yeah, I wanted to build on what you said. So I think that's a really good question. And in the class that I teach here at Lewis and Clark in the summer, we talk about IACUCs. And the first thing to remember is this isn't a self-regulatory system. So that gets to some of the issues, the transparency issue, because when something is self-regulatory at an institution, it's kind of hard to look under the hood, maybe impossible sometimes. The other thing is the appointment of the societal member to the IACUC. I've for a long time advocated that position should be for animal lawyers. But I've not yet really had anybody bite that, okay? I think it would be great if we had an advocate in that position, but we don't. So we need to do that. The other thing to keep in mind, and we didn't have a chance to get into this, and Lenore, if you want to follow up on this too, since this is really, I'm bleeding into your talk a little bit. The IACUCs themselves are limited as to what they can review, okay? An IACUC is not like a human institutional review board. You're not really charged on an IACUC with looking at the ethics of the experiment. You can look at the number of animals, you can look at the welfare of the animals, you can look at the enrichment, but you can't say, oh, this experiment isn't ethical. The other thing you can't do, and this relates to the sepsis litigation you were talking about, is you can't ask the question, well, you've done this experiment 4 or 5 times, or X university or X institution has already done this 4 or 5 times. We're really not getting anything out of this. Do we need to do it again? So there are limitations as to what IACUCs can do. And they're built into the Animal Welfare Act as well as the Health Research Extension Act.
They don't design the experiment. They don't tell the researchers or scientists what to do, but they do evaluate the humane care of the animals.
Yeah, actually, if I could add, I think it's really interesting. They're like, one thing they can do under the Animal Welfare Act is if they approve a protocol, they can sort of exempt their general husbandry requirements under the Animal Welfare Act. So they do have some power, and I think that one of my critiques is that it could sort of be a rubber stamp power potentially. Now I think they would disagree, but in my mind, since it is self-regulatory, and I'm not aware of I mean, I guess I can imagine the theory, but I'm not aware of any litigation where someone's actually tried to hold an IACUC member responsible for the research. You know, that I don't know that I don't know that accountability is really there to make sure that it is more than a rubber stamp. So
Yeah, if I could just comment on that. First, just to disclose, I was one of the committee members that worked on the last version of the guide for the care and use of laboratory animals. I'm going to talk about that, so I want you to know that. You got to kind of look at that, because even though it's not a regulation, it's really what people should use for best standards. And I think Christopher's skepticism is well placed. There are two stops, though, that you should really keep in mind. The first is that no researcher will have their research accepted in a journal. No researcher's research will be accepted as good research unless the animals are treated humanely. Why is that? Because, I mean, think about it. If you're studying a creature that's under stress and not well cared for, the results you get just aren't any good. So that is, you know, one thing that kind of prevents, at least in my opinion, some egregious abuses. Not in all cases. And we can't tell because the system is not transparent. And the other thing is that very often there is outside accreditation by some organizations, and that has been criticized as not being rigorous enough. So there are some stops in the system, but bottom line, I think, at least I think the three of us would agree, just I know based on your writings and what you said in your talk, more transparency would really, really help the system.
Thank you.
There's an online question.
Okay. So someone is asking, as Christopher touched on with the example of the kittens who continue to be tested upon, even though there was already treatment for the condition, why do you think companies continue to test on animals, even when the condition, drug, cosmetic they're testing for has already been cured or found to be safe for humans?
I mean, I'll throw out a couple ideas. It could be reputational investment. So in the case with the kitten experiments, this was a researcher who was employed by the university, right? So it was not necessarily, I guess I'm not aware of what the financial incentives would be offhand. Maybe there were some intellectual property financial incentives for them, but at least certainly like professional reputation. You know, they had a vision of doing something a particular way and sort of wanted to see that through. And another reason would be, I guess, if you couple that with the availability of resources. So if there is some motive to do it, whether it's financial or professional reputation, and the money's available and it's still being given to you, then that sort of thing can sort of self-perpetuate without a good reason, until someone exposes the light on it, or until something jostles that environment enough to disrupt that relationship. That'd be my hypothesis. So.
Yes.
Hello, I live in Michigan, and at Wayne State University, there have been these dog experiments for about 30 years. And they do invasive surgery and put them on treadmills, and they're just horrible. And the researcher continues to get funded by the NIH. Is there anything, you've talked about some laws that encourage alternatives. Is there anything like that for NIH grants, or could there be, that they have to take that kind of thing into account and not fund research that keeps doing the same animal experiments over and over?
Yeah, can I take that one? So that's a really good question. First, I just say that one of my former postdoctoral fellows, Michaela Singer, wrote an article. I also contribute to the article, but it's really mostly her work about the NIH granting process and how it could be changed to be more alternatives friendly. So stay tuned. That should be coming out in a law review near you very soon. The question you asked, though, gets really, I think if we're going to generalize it, is how do we know when our societal dollars, which go to NIH and go back out to researchers, are being wisely invested in the science? That's an important question. Because if the same research is being done over and over again and it's not yielding scientifically valid results, then there's a problem there. And I would say we really don't have the sort of system yet that we need to police that. It's difficult to know because the process is very decentralized. It's very entrepreneurial. There's not some integrator in charge at NIH or at the White House Office of Science, Technology and Policy that looks over all the research and says, oh, we don't need this, we don't need that. So the question you asked is very legitimate. I don't have a good answer for you. One thing you could do, and then this gets to kind of the policing function, I think that you mentioned, Christopher, and is you can look in the journals and to see if anything has ever been published out of the research. This has actually been used in the past as an effective litigation start. And if there's a researcher that's been working on a particular technique for 5, 10, 20, 30 years and nothing's been published, I would say that should raise some eyebrows in the scientific community, and it should provide you with a way to ask some serious questions about why this keeps being done. But we don't have a way right now of moving that off into alternatives until we really develop the alternatives. That's more what I was talking about in my talk. We need to fund those so that we're not needing the animal models as much.
If I so just thinking about that, one thing that strikes me about animal law and animal advocacy is that there's probably like a million different issues, right? Like you could almost do have one person do an entire campaign just around funding of this one experiment, to say nothing of other experiments or things that have nothing to do with animals and research at all. So it's there's just like so many things that can be done is what I'm trying to say. Hopefully I hope people feel a little inspired that you actually, that for this experiment, for example, send a letter to the NIH and explain why you think it's bad. You could even CC and make sure that the NIH knows that you're CCing your local federal representatives, that like senators, for example. You could just so that it's on the radar. You could maybe CC some other people so that so they know that it's being looked at, and the decision makers might actually give it more scrutiny if they know that they're being watched. And then if you don't like the outcome, then send a letter to the NIH's Office of Inspector General and include that correspondence and make sure to CC the decision makers at the NIH. And if you see keep an eye on the USDA database. If there's an inspection report where they had an animal welfare incident, then make sure that you highlight that, and you make sure that and then maybe you could even call into question the proprietary, whether the research results are valid or not based on those animal. And so it's it's like, I think maybe something could be done. It could just be kind of a house of cards, and people are just it seems so overwhelming and daunting, but putting a little bit of energy into it could also.
This has been a really intractable issue. And you mentioned writing to the NIH. My state senator and state representative wrote to the NIH and probably would have gotten more attention than if I did.
Mm-hmm.
And I spoke with her, my state senator, recently, and she just said there wasn't a good response, or there was no response. But I think I will follow up with her. I've contributed to her campaign, but to see if she asked her to follow up with the Inspector General, that might be something.
Yeah. And I don't know the particulars of the experiment, but it's just, we should make sure people are making good decisions about this stuff. So anyways.
Thank you.
I think we have time for one more question online.
Great. So Martha commented, the IG of the USDA has produced audits for at least 2 decades showing fines were de minimis and negotiated by the violator. So has there been no change in 2 decades?
Is this about, I'm sorry, is a question about penalties
Yes.
at the USDA?
And being the penalties being negotiated by the violator themselves.
Oh, I'm sorry, I don't have any knowledge on that.
Aware of that particular issue, but I would maybe point that questioner to, there was a great law review article that I read by Delciana Winders about investigations, enforcement, and penalties. So perhaps that might shine a light on that issue.
Yeah, well, right, so that's the Office of Inspector General. That was like the audit where they were saying it's like the cost of doing business. And I think my answer would be no, I don't think anything has changed in the last 20 years. Although well, maybe not within the USDA itself, but I will say there has been a lot of attention, a series of Washington Post articles about lackluster enforcement of the Animal Welfare Act in recent years. And also lawsuits by nonprofit organizations like the Animal Legal Defense Fund, but also PETA and other groups that sue the USDA for their lackluster enforcement and are I think winning at a remarkable rate, because Administrative Procedure Act cases are supposed to be very hard to win, but the USDA is so, I think, brazen in its flouting of the law that that federal judges have been holding them accountable for their policies as too in recent years.
And with the USDA, we don't just see that with the questioner's reference, but with puppy mill oversight and oftentimes coming to arrangements with operators, and it's a big problem. Well, that's all about the time that we have today. Thank you all for joining us for this panel.